Good morning and welcome to the Hawaii State Senate Committee on Commerce and Consumer Protection. This is our Tuesday, February 6, 9:30 a.m. agenda in Conference Room 229 at the Hawaii State Capitol. This meeting is being streamed live on YouTube, and in the unlikely event that we need to abruptly end due to technical difficulties, the committee will reconvene and discuss any outstanding business on Wednesday, February 7th at 10 a.m. and a public notice will be posted on the legislature's website. As is our customary committee protocol, if you are testifying remotely, your audio will be muted and video disabled until shortly before it is your turn to testify. We have a significant number of measures on this agenda with a lot of live testimony, either in person or online, that intend to submit testimony. So in order to make sure that we adjourn this 90-minute committee hearing slot with votes on these measures so that we don't defer to a later date, it is our customary protocol to ask you to limit your remarks to 2 minutes. We have reviewed all of the written testimony that's been submitted. So like I normally try to recommend, feel free to use your 2 minutes to elaborate on your written remarks, but please, if you intend to read them verbatim, word for word, I would encourage you instead to stand on your testimony because we've already read it, or like I said, add any individual comments you'd like to clarify or add in addition to. And if you'd like to stand on your testimony, that's even better. We'll appreciate that and allow for more time from other testifiers. And as is our protocol, we recognize the Senate rules of decorum in this hearing room. So I would ask that you please limit your remarks to the substance of these measures. Personal criticisms or attacks against other testifiers or individuals that are out of scope of the content of the bill will not be tolerated. And I will ask that we move on because we got a lot to do today. So otherwise, please feel free to use your 2 minutes accordingly. The first measure on this agenda today is SB 3205 relating to condominium associations. This measure establishes the Ombudsman's Office for Condominium Associations within the DCCA. First up, we have the Department of Budget and Finance offering comments. Okay, Mana Moriarty for the Office of Consumer Protection with comments. Good morning.
Good morning. Good morning and thank you. You've received our comments. Taking no position on the merits of the bill, but with concerns about placing this within OCP, the Office of Consumer Protection. In 1969, when this legislature created the Office of Consumer Protection, it was given a mission that is very different and in some respects could be viewed as inconsistent with placing the ombudsman in the office. I'll just give you one example, and that is the enforcement authority granted to the Office of Consumer Protection is to enforce laws enacted and rules adopted for the purposes of consumer protection. There is nothing in OCP's statute that allows or even contemplates enforcing civil agreements between private parties, for example, the governing documents of an association of homeowners. And I would submit that it's a pretty significant departure from the mission of OCP to expand to include those types of functions. Thank you, and I'll be available for any questions.
Thank you very much. Next we have for the Real Estate Commission, Caden Kleinhans online with comments. Good morning.
Good morning. Morning, Chair Kilkalole, Vice Chair Fukunaga, and members of the committee, Keating Kleinhans, Senior Condo Specialist, testifying on behalf of Derek Imani and the Commission. You have a written testimony to provide some highlights. We support the intent of this bill. We shared concerns on certain sections, particularly sections that do not pertain to the actual creation and administration of the Ombudsman's Office, such as board member certification and continuing education. We believe those sections might introduce more complexities that will further complicate this proposal. We're also concerned with the proposed funding language to Section 514B71, subsection B, including the transfer and integration of condo specialists to the proposed ombudsman's office. Without those specialists, the commission would necessarily be unable to execute any of its programs of work related to condominiums. We have provided recommended amendments addressing these concerns for your committee's consideration. Thank you, and available for any questions.
Thank you very much. Next, we have the Kokua Council in support.
Good morning,
Morning.
Chair, Vice Chair, and members of the committee. Mahalo for the opportunity to testify in support of Senate Bill 3205, which proposes a condo ombudsman's office within the DCCA Office of Consumer Protection. There are many benefits proposed in Senate Bill 3205, including that it will allow owners to pursue their rights under the law that they would otherwise not do so because of cost. Justice that is available to only those who can afford it is not justice. Please pass Senate Bill 3205 to provide condo owners with fair access to justice. Mahalo.
Thank you very much. Next, we have Richard Emery of Hawaii First Realty in opposition. Good morning.
Good morning, Chair and members. My name is Richard Emery. I'm a longtime industry person, having been in the condo management business and retired from that in 2011. But for the last 13 years, I've acted as an expert witness on matters relating to disputes between homeowners and condo associations. And that includes representing homeowners as well as representing condo associations. As I've testified in writing, you can see the types of claims that are being made today are much more severe than the simple thing about getting documents, whatever it may be, because I have cases where there's a murder involved and complaints made against the association for security, violation of building codes, tearing down load-bearing walls, which have all gone to court because that's the proper place for it to be. So I would say I'm really recognize that not all condo boards are successful or do the right thing. I support the later bill today, which the Legislative Reference Bureau would take a deep dive. For 10 years, I have been the liaison for CAI with the other states. I understand fully what those other states do with regard to condo disputes. So I think we should take a deep breath and support the Legislative Reference Bureau initiative later on in this agenda, and we should defer this bill. Thank you.
Thank you very much. Next, we have District 25 Council of the Democratic Party of Hawaii, Kim Koko Iwamoto, online in support.
Yes, thank
Morning.
you. Morning. I thought I was speaking on behalf of the Chamber of Sustainable Commerce, but if it's okay, can I wrap up with my testimonies in support of this bill? Basically, as you know, for many kupuna especially, they're the most valuable asset. Defending and protecting that asset can become really costly, and they may be on a retirement income. And so using arbitration and sometimes there's an imbalance of representation because they can't afford an attorney, but the association and the management company may be able to afford that representation. And as we've heard on prior bills last session, that even the arbitrator won't tell the condo owner what their rights are. And they often don't tell the condo association what their responsibilities are. An ombudsman would do this, would just say, hey, listen, this isn't a question of fact or dispute of fact here. This is just about, you need to show the documents. You need to get several bids. It's very straightforward. If the law is written in a certain way, they communicate it and referee without needing all of these professional, expensive advocates on behalf of both parties. And the other issue is education, educating board members. Of course, they should know what their fiduciary duties are. And when you hear testimony from a board member saying, oh, we don't have time, again, it's a very valuable asset to our kupuna, and they need to know that they will be responsible for their decisions. Thank you so much.
Thank you very much. Next, we have Dale Head In support? Good morning.
Okay. Hey. Thank you for the hearing. My name's Ed. Yeah, I was out in Wai'i for about 35 years at a condominium complex, a big one. And the bullying that goes on from the board against the owners is just astounding. And 514B gives them unfettered authority. It's really unfair. So from the perspective of consumer protection, these residents and owners who are taxpayers need a forum to express themselves and get a fair deal. We're not getting it right now, okay? And I'm in favor and fully support this bill. Thank you.
Thank you very much. Jeff Sedino, in support?
Good morning, Chair, Vice Chair, and member of the committee. My name is Jeff Sedino, and I strongly support a cheaper alternative to litigation. We often hear of condominium owners who have lost their homes and went bankrupt through expensive litigation. The eagerness of attorneys to engage in expensive litigation, the disproportionate size of attorney fees compared to the issue under dispute, and the weaponization of attorney fees are all problems. I want to be explicit about what this actually looks like using my own story. My association has filed 2 lawsuits against me, and I was guilty until proven innocent. To defend myself, I had to spend literally every single dollar I had and survived only through cash advances on credit cards. I've worked very hard my entire life, even as a successful financial advisor, but I sincerely believe that I was going to lose everything that I had ever worked for. This extreme stress caused me to begin having optical migraines, where about once a month, I lose about 30% of my vision for about 30 minutes. It also manifested in bald spots where my hair stopped growing. There were other things, but suffice to say that even as an established financial advisor, I stayed up at night worrying about how I was going to pay for basic life necessities. Separately, my heart goes out to the stories I have heard of elderly retirees who are being threatened with complete and total financial destruction at the end of their working lives, sometimes over something as trivial as $300 in contested fines. Like vampires who drain the life out of their victims, these attorneys drain all the money out of the bank accounts of condo owners. When there is no more money to take, they move on to find their next victim. Please give us a system where we can afford to defend our innocence from the attorneys who are making a financial killing off of the current system. Thank you for the opportunity to provide testimony.
Thank you very much. Antonio Vieira, in support? Good morning.
Morning. Aloha, chairpersons. My name is Antonio Vieira. I have given written testimony as to my concerns and in support of SB 3205, and wish to give testimony that I'm actually a witness as to the abusive nature of the associations and the board members. Unfortunately, when the boards and associations are abusive to employees and not only to the owners, it causes a great deal of legal expenses. I've been forced to, on 4 separate occasions, take litigation action against the associations. I prevailed in all 4 cases because of their conduct. I wholly support this bill, and I think there's a need for an investment office be in process here. It can be used as a educational tool for the associations and the board of directors. A lot of these board of directors don't have any experience or knowledge of how a board is run. They're retaliatory. I'm subject to retaliation. I'm in the subject of harassment. And with an enforcement branch in place, I believe this will help the industry. It will also be an educational tool to the industry. So I'm here to give testimony in support of SB 3205, and I hope that an investment office can be created for the protection of not only the owners of the properties, but also the employees that work under the abusive nature of some of these associations and board members. And I thank you for your time.
Thank you very much. Lourdes Scheibert, in support? Good morning.
Very much. for giving us this opportunity to be heard. I'm just going to highlight what my written testimony contains with a little bit more. I've uncovered a flow chart from 1991 created by Gregory Tanaka's report, Condominium Dispute Resolutions, written for the Real Estate Commission. In Tanaka's revised flowchart, there is an inclusion of a DCCA ombudsman. Considering that the current alternative dispute resolution method has remained unchanged since 1990 and has not effectively resolved disputes, it is now necessary to implement a flowchart similar to Tanaka's. This is especially important due to the negative impact of non-judicial foreclosures on the resolution process. Quote from Mr. Tanaka's 1991 report reference to condominium attorneys. As long as even one association attorney advises his or her clients to take everything to court, there will be a high cost to dispute resolution, special assessments to pay for attorneys, unnecessary overkill of small cases, insensitivity to the legitimate concern, a building up of institutional resentment, and a high psychic cost of litigation. In practice, only a very small percentage of cases should wind up in the courts. Attorneys can do much to steer the balance of cases to far less expensive avenue. Please pass SB 3205 to the next level for the opportunity for more public review. Thank you.
Thank you very much. Next, we have Christine Morrison in support. Marcia Kimura in support.
Yes, hello, thank you for this hearing. I support this partly because of a great feature in it that allows for the ombudsman to remove board members guilty of malfeasance. You know, as some of us, myself in particular, have gone through a recall experience of our board. It can be very cumbersome and long-winded procedure which ends in failure, partly because so much time and procedure has been expended on it. And I do love the swiftness of the powers of the ombudsman, among other advantages of the bill. Thank you.
Thank you very much. Greg Masakian in support. Good morning.
Good morning. Aloha, Chair, Vice Chair, and members of the committee. My name is Greg Masakian. I currently serve as Second Vice President of Kakua County, Subdistrict 2 Vice Chair of the Waikiki Neighborhood Board, and a Director at my condominium association, the Keoni'ana AOAO. I co-authored SB 3205 together with Lila Moore, the President of Kakua Council and Vice Chair of the Condominium Property Regime Task Force. And I thank the committee for giving the public a chance to make their voices heard today. Condominium owners throughout Hawaii currently have nowhere to turn, as our legislature has not provided them with the proper state office to assist them. SB 3205 places the Ombudsman's Office under the DCCA's Office of Consumer Protection, which has substantial enforcement provisions within Chapter 487. It will not only be an office for all condominium owners and associations to resolve disputes, it will be a deterrent against potential bad acts of board members and others overseeing associations. Hopefully, we'll think twice before engaging in misconduct. I previously forwarded you an issues paper for the Hawaii Real Estate Commission, authored by Gregory K. Tanaka and dated January 1991. The title is Condominium Dispute Resolution, Philosophical Considerations and Structural Alternatives. Even back in 1991, it was clear that an ombudsman was recommended as someone that could address the issues and concerns of the residents of Hawaii and be cost-effective for everyone, reducing court cases and litigation. It was clear Hawaii needed an ombudsman in 1991, and it's clear Hawaii needs one now. The residents of Hawaii simply want a place to go to get enforcement of the very laws our legislators introduce, debate, and enact with Hawaii Revised Statutes 514B and other statutes. And as I said in my written testimony, I know this is the year of the dragon, but let it also be the year of the ombudsman. I ask you to please pass SB 3205 and help over 1/3 of
Thank
the
you very
population
much.
of Hawaii live better lives. Thank you.
Edward Sue in support. Steve Glanstein in opposition.
Good, good morning. Good morning,
morning.
Chair, members. I've submitted written testimony. Just a few comments on this. I tend to have a more balanced view. I apologize for my voice getting over bronchitis, and so I didn't want to infect you guys. But I'm looking at a more balanced view that if you're going to give this ombudsman the authority to remove somebody from the board, consider giving the authority to remove somebody from an association as well. We've had association members cut holes in support walls, threaten board members. Right now, I have an association president who will not leave her home because of threats that have been made to her. So that type of thing needs to stop from either side. The bill is huge. It's about half the size of Chapter 514B, and just slamming it in is probably not a good idea. As Senator McKelvey used to be Representative McKelvey, we tried this about 10 years ago. We looked at it to make a condo czar. So and that didn't go anywhere. That had serious problems. So I'd ask that you look at it in a more balanced approach, and I am opposed to it in its current form. Finally, Chair, I do have to say, as a professional parliamentarian with over 2,000 meetings, I really appreciate your establishing rules of decorum and making it clear that you're going to maintain them during the hearing. Thank you.
Thank you very much. Finally, we have, excuse my pronunciation if it's wrong, Tigalapan in support online. Hello, are we there? I think we have
Yes,
you, but
yes.
it's blurry. Okay, please proceed.
Tiga Lapan is here.
Please proceed.
Yeah, I actually am brand new on this, and I am a homeowner in the same kind of condo situation. Apparently, I already submitted a written testimony, and I guess I have 2 minutes, right, to talk?
Yes, please.
Okay. Well, I agree. I support this SB 3205. And also what Dale has said, and William Grafina, Bigna, Antonio Vieira, Lois Schreiber, we all share the same kind of problem at our condos. Apparently, the board, even though they're homeowners themselves, they seem to think that they have this power of us. They abuse they use their position to intimidate, and they think they're they're above us and they can do whatever they want to do. Okay, so as a result, I'm the only one that is the whistleblower and sticking out my neck for everybody, and I'm labeled as the troublemaker because I'm speaking up and standing up for my rights. And as a result, I've been threatened by the board as well as by the association's attorneys, which I am paying for from my HOA fees. So all these things needs to be changed, and I think we should have more support for the person that has that's no power. I'm elderly, disabled, and a widow, so I really don't have much resources or funds to hire these high-powered attorneys to fight something that is totally wrong. So I thank you for this opportunity to speak up today, and I hope something can be done to improve the situation and protect.
Thank you.
Thank you.
Thank you very much. That's all the registered testimony we have on this measure. Is there anyone else in the room or online who would like to testify? Okay, we'll start with you and then, please. If you can introduce yourself, and you have 2 minutes.
My name is Nancy. I'm a retired registered nurse. I live in a condo and have been in various ones for the last 43 years. I'm very concerned about
Can you please register
I'm-
your support or
Oh,
opposition?
yes, I'm in absolute strong support. And I'm very concerned about the status of the condominium boards and their abuse of power. I've experienced it myself, as most of the people that have testified in person and on the TV, they seem to be nice people. I mean, they don't seem aggressive, they don't seem angry. They're common people, they're mainly elderly. I think this bill is very important. Senate Bill 3205 is the pillar of the rest of the bills, especially Senate Bill coming up, what is it? 2534, that's total litigation. No one can afford this. I can't afford it. So we need some kind of tweaking of this bill, perhaps if no one likes it, but we need something. And we need it quickly because we do have abuse of power on the boards. I've seen it myself, and no one can afford to hire an attorney. We just can't do it. So I strongly am in support of it. We need to do something. We saw that we even have stress-related outcomes. I've had stress-related outcomes as well, so I can attest to that. Thank you so much for having this hearing.
Thank you very much. Please. Good morning.
Good morning, Chair, Vice Chair, committee members. My name is Phil Nerney. I chair the Legislative Action Committee for CAI, and we did submit written testimony. I apologize if that was overlooked. CAI opposes...
Oh, I'm sorry, I missed you. Thank you for stepping
I was scared.
Yeah.
No,
we got you.
I might have failed. CAI opposes this measure for two specific reasons. One, last year the legislature appointed a task force to study questions, including an ombudsman. Excuse me. The task force unanimously recommended that the Legislative Reference Bureau study this subject together with other subjects. Having objective data rather than anecdotal reports will be a better basis upon which to legislate. Substantively, this bill has a number of problems. It's been presented in a variety of forms in the past, been repeatedly rejected, and it is constitutionally infirm. Thank you.
Thank you very much. Is there anyone else who would like to testify? Okay, seeing none, members' questions. Okay, I have a question for, I think we'll start with the Office of Consumer Protection.
Good morning, Chair.
Hi, Mona, good morning. So, some of the testimony that has come up this year and in this hearing and then last year points to accusations of unethical or even illegal behavior engaged in by members of boards, but also by attorneys who are licensed to practice in the state of Hawaii, and mediators and arbitrators who I assume are also licensed to practice. Is your office aware, or have you ever engaged with condominium residents or members and directed them to file those types of complaints with the Judiciary's Office of Disciplinary Counsel?
Yes, Chair. So if there's a complaint about an attorney's conduct, including an arbitrator or mediator, our office would direct the individuals who have the complaint to file with the Hawaii Supreme Court's Office of Disciplinary Counsel.
And is that a regular occurrence?
It happens from time to time. I couldn't tell you how often, but we're no stranger to those.
And what type of outcomes, if in fact that process nets out a result that determines that there was some improper behavior, what are normally the outcomes of those types of proceedings?
You may want to check with them. As far as I'm aware, they can issue sanctions against the attorney's license, including up to revocation, disbarment, essentially, of the attorney's license.
I know it's a little out of your scope, but the judiciary is not here. So is restitution one of the potential?
I'd have to check on that, Chair, and get back to you.
Okay, thank you.
Yeah.
Members, any other? Vice Chair.
I'm sorry, not so much for Office of Consumer Protection, but for Mr. Kleinhans, representing the Real Estate Commission, if he's still online.
Morning, Vice Chair.
Okay, with respect to some of the kinds of complaints that have been identified, do you have any information as to RICO's involvement in pursuing investigations into these kinds of complaints?
Rico, so I have some data. Let me see if I can find it, but at least within the past 5 years, well, not counting this year, but they have authority on documents requests and licensing violations. But with regard to document requests between 2018 and 2023, they've received, and again, I can't speak for Rico, but this is the stats I was provided. They received around 131 complaints relating to records requests from condo owners between 2018 and 2023. They put for perspective, the total complaints they receive in 1 year was between 2,500 and 3,000, just because they handle so many professions and vacations. And of those 131, in those 5 years, complaints pending was 61, and then the remaining were closed. 31 were closed, further action not warranted. 26 were closed and resolved by parties. 11 were closed with legal action imposed, such as fines, and 2 were closed with warnings issued. So that's the data I have from RICO. For disciplinary actions, it's primarily licensing violations, so managing agents. I only had time to look through the disciplinary actions from issued in 2023. So there were 19 disciplinary actions issued against real estate brokers, and then 2 were those involving the condominium law out of those 19.
Okay, perhaps if we could ask for any additional information that you may have on RICO's disciplinary actions for years between 2020 and 2020 through 2022, we would really appreciate it. Thank you.
Any other questions?
Sorry, Vice Chair, that was 2020 to 2022? Or, I'm sorry.
2020 through 2022, because it seems as though the number of complaints and concerns have been increasing in recent years. So just trying to get a perspective on the types of complaints as well as their disposition.
Okay, will do. Thank you.
Mr. Kleinhans, I have a follow-up.
Hi, Chair.
This may not be directed specifically at you, because I'm not aware of apprised of who submitted the testimony from your office. But I am concerned about the testimony. Your office submits concerns about certain sections of the bill, but then supports, I guess, the remainder of the intent of the measure. I can understand that the drafters put together a measure that empowers an individual to avenge injustices perceived on condominium unit owners, but this bill proposes to empower an individual with almost absolute authority, absent judicial review, to undergo quasi-judicial proceedings and enforce those outcomes on private entities in a way that does not appear to exist anywhere else in the Hawaii Revised Statutes, and in a way that does not appear under the ombudsman's authority present in any other state in the country. This is proposing a condo sultan, more than an ombudsman. And so I'm wondering why your office neglected to submit comments on that portion of the measure.
Well, we support the intent. We were primarily focused on it's a good dialogue. We believe that the dialogue deserves merit just because we see condominium issues arise every year. And then we did provide.
But are
that,
you
know,
really okay with an individual who has the power to subpoena private records and individuals and entities to remove duly elected members of private entities, who is not subject to judicial review, who is not subject to term limits or any public vetting at all, not subject to Senate confirmation? I mean, you don't have any comments on that. So it's almost as if you're supporting those types of steps. This is an ombudsman that would not, that would be empowered in a way that doesn't exist anywhere else in the country.
Right. We understand that there's legality issues, and I know in previous bills that was introduced that the AG provided testimony on that. So what we want, if the committee wanted the bill to succeed, we recommended that it would focus on the actual creation and the administration, and not so much the other supplementary provisions. We also added in our testimony that maybe it might be preliminary. There are task forces that are looking into the successes of the ombudsmans and the differences and the pros and strengths that the other states employ. We are aware of the certain sections, but we support the intent of the bill to assist condominium owners. I apologize if that was interpreted on the broad and whether or not the certain stuff we support may address, maybe have legal concerns.
Well, like I said, I'm not directing it at you personally. It's the position of the office that this is more directed at. But thank you. Any other follow-up questions? Okay, we'll move on to the next measure. This is SB 2108 relating to renewable energy tax credits. Allows a condominium association that claims a renewable energies technologies income tax credit under 235-12.5 HRS to transfer the credit or portion thereof to another individual or corporate taxpayer that is not related to the condo association for fair and reasonable consideration. First up, we have the Department of Taxation offering comments. Good morning.
Thank you. Chair, Vice Chair, members, Eliza Watson from the Department of Taxation. The department stands on our written testimony offering comments, but we request an amendment to better track the sale of this credit. The department would like to request to move up the deadline for the condominium association to elect to transfer the credit to the 20th day of the 4-month following the close of the taxable year. This would serve as a notification to the department that the condo association has qualified for the credit, and further, it'll identify who they're selling the credit to. The buyer of the credit or the transferee will still have 12 months following the close of the taxable year to claim the credit. The department can provide language to help accomplish this request if necessary. Thank you.
Thank you very much. Tax Foundation with comments. Good morning. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We have submitted written testimony. What I wanted to, focus on is that not all condominium associations are the same. Depending on the structure and the tax elections made by the association, it could be treated either as an entity or as a pass-through for tax purposes. And if it's the latter, if it's a pass-through, the owners may have rights to the credits, and at a minimum, it may be setting up a dispute between the owners and the association as to what to do about the credits. Some owners perhaps may question the price that a particular credit's being sold for, and issues like that. And I'm not sure how or whether the owner's rights can be cut off by a transaction such as the one contemplated by this bill. I'd be happy to answer any questions.
Thank you very much. Samuel Wilder King II in support.
Aloha, Chair and Vice Chair. Thank you for having me. This is something that I think is a great idea. I think you see from my written testimony that this is kind of my brainchild. One of the things first off, I want to support whatever Tom is saying. Tom's very astute on tax issues. I support the DOT's comments as well. I would be interested in looking more at their deadlines, but fundamentally the thing to think about also is harmonization with the federal taxes. I saw in the Tax Foundation's submitted testimony that there's still some play with the Fed. So I think there's a number of things that still need to be looked at. However, I think it's worth passing out a committee to continue the conversation. One of the things that I would recommend is increasing the amount of credit available. Right now it's $350 for condo units and it's $5,000 for individual homeowners. I'm not sure why individual homes, single family detached homes would be entitled to a higher credit. I was bouncing some numbers off a gentleman I got a quote from for installing solar panels on my building, which is a 78 unit building, of which I'm the president of the Homeowners Association. And the project would have cost about $2 million, $2.3 million. So if I got $5,000 per person per unit per 78 units, I'd only get like $390,000. But if I only get $350, I'm getting like $78,000. So it's a much stronger financial incentive, obviously, if I'm getting a tax credit that's equal to what single family homes are getting. And obviously denser living is going to be reducing carbon footprints, going to be allowing people to have a more affordable cost of living. So it'd be very beneficial to have a higher tax credit amount. However, I think given the Tax Foundation and given DOT comments, there's some more things to work out. But I think at this time, it's an idea that's worthy of passing out a committee and continuing the conversation. I'm available for any questions.
Thank you very much. That's all the submitted testimony we have by individuals who indicated they would be present. Is there anyone else who would like to testify? Okay, seeing none, just to note for the record, actually, on the prior measure, there were 24 individuals submitting testimony in support, 23 in opposition, and 3 with comments. And on this measure, there were 2 individuals in support and 2 with comments. Members, any questions? Okay, seeing none, we'll move on to the next measure, SB 2336, relating to condominiums. This requires that condominium renters who prevail in a lawsuit for a violation of the Residential Landlord-Tenant Code be awarded reasonable attorney's fees and costs and threefold damages. First up, we have the Real Estate Commission in opposition. Good morning.
Morning again, Chair, Vice Chair, members. We sent in our written testimony opposition just on part 3 of this bill. Thank you.
Thank you very much. CAI, Mr. Nerney, in opposition. Thank you for standing on your testimony. In opposition, Jeff Sedino, in support.
Good morning again, Chair, Vice Chair, and members of the committee. My name is Jeff Sedino, and I strongly support an oversight board. Over 50 years ago, we were the first state in the country to create condominium law. Today, we have the worst condo governance in the country. The trade industry has been at the forefront for decades, and this is the best that they can do. I've been advocating for 6 years. Every significant reform was initiated by individual owners and opposed by the trade industry. For example, the most important reform, which partially reformed debt collection practices, was initiated by an owner and fiercely opposed by the trade industry. After becoming law, other states have used it as inspiration for their own debt collection reforms. As another example, individual owners successfully advocated for a bill to stop non-judicial foreclosures. However, the trade industry successfully lobbied the governor to veto the bill. What did the trade industry do with this awesome power to foreclose? In December, they sent an elderly lady a demand letter threatening to foreclose on her home for the trivial amount of $300 in fines. The trade industry, with all its financial resources, human resources, and national resources, should be taking a leadership position to improve condo governance. Instead, they fight to preserve the status quo of worst governance in the country, as we heard during the first bill today. The trade industry has forfeited the privilege to police themselves. They have forfeited their leadership role in condo governance. Last year, a prominent member of the trade industry answered your question, stating that there exists only an irreducible number of problems in our condo governance. If they do not want to be part of the solution, then I see no benefit to including them in the conversation. This bill will cost the taxpayers nothing. Please, for the oversight board, please create this oversight board. It is obviously needed. Thank you for the opportunity to provide testimony.
Thank you very much. Dale Head, and support.
Thank you. Add a little bit. In my decades in the condo complex out in Wai'i, over a decade on the board, bullying is a terrible problem created by 514B because it's not enforced by the state, okay? Like 3 times I asked for documents as a board member, I never got them. And the last time the DCCA so-called investigator that only makes phone calls told me, oh, the documents are lost. They're not lost. I told her right where they were, okay? I told her exactly where they were. She ignored me and chose to believe the property manager who works downtown. And this guy will provide us with baloney untrue minutes for the annual meeting because they're in control. They appoint the board president through proxy abuse. So from a consumer perspective, we need an oversight board. That should have been first and loaded into the system before they spent all these decades tinkering with 514B, which the state doesn't enforce. Thank you.
Thank you very much. Greg Masakian, in support. Good morning.
Thank you for allowing me to speak again. I fully agree with the last 2 members of the public who raised concerns, and I stand on my written testimony. I think that this is another area that, you know, it's a different aspect of what we're looking at right now. It's specific to renters and the abuse of power, but it all falls in line with abuse of power. So I appreciate the committee when they look at all of these bills today. There's quite a few that you collectively look at. I hope all of the testimony from one of them, and some of them go hand in hand with others. So I appreciate the time to add that comment. Thank you.
Thank you very much. That's all the registered testimony for in-person that we have. Is there anyone else who would like to testify? Okay, seeing none, I'd like to note that, oh, please.
Nancy Manelli Leonardo again. I'm in support of this. And basically, I just want to talk about the abuse of power and the case where the lady was going to lose her home because of a $300 issue with her AOAO because she put a shoe rack out in front of her porch that wasn't in compliance with what she was supposed to do. And they were going to start on a big lawsuit with her. She can't afford it. In Civil Beat, this case generated close to 140 comments. And these were comments from basically in support of her. So what I'm trying to say is that this is the tip of the iceberg. What you're seeing here today, what you're seeing online with the few people that do speak out, do come here, you know, it's just the tip of the iceberg. So we need to do something. All of these bills today about the condominiums, they interconnect. If we're not going to do it one way, we have to figure out another way. But we do need to have somebody that's going to hear these cases and make a resolution or a solution for them, because people can't afford to go to hire an attorney. And so it's in your hands. Consumer protection, we definitely need it. Thank you.
Thank you very much. Is there anyone else who would like to testify? Okay, seeing none, I'd like to note that we received in total 5 individuals who submitted written testimony in support, 23 individuals who submitted written testimony in opposition. And we will move on to the next measure, which is SB 2404. This measure prohibits, relating to condominiums, this measure prohibits the use of proxies in condominium association voting. First up, we have Richard Emery in opposition. Good morning.
Good morning, Chair and fellow committee members. Annual meetings are more than just election of directors. You approve tax rollover resolutions, you approve, maybe you have an architect there talking about changing the colors of the building. There's a lot of things that are accomplished at the annual meeting of a condo association. And proxies have been around for 1,000 years, since the trade began in the Mediterranean. If you look at corporations across the United States, it's not uncommon to have proxies for for-profit, not-for-profit, condominium associations across the United States. And a proxy is a voluntary, independent right of the person who is a stakeholder, the owner in the case of a condominium, to choose who he wants to represent at this meeting. A meeting that may have things that come on the agenda that weren't originally planned, which is the right of owners to make, proposals during a meeting. So I think it's just improper to say who I can give my proxy to or I cannot give my proxy to. I have not seen, as a parliamentarian and having attended hundreds of meetings, this so-called board of directors majority that has this tremendous control over all of these meetings. There's 175,000 condo units here in Hawaii, and I just think it's improper to tell an individual stakeholder who and how he can give his proxy to somebody. It's a personal right, it's a personal choice. Thank you.
Thank you very much. Richard Ekimoto in opposition. Good morning.
Good morning, Senators. I'm testifying on behalf of the Hawaii Legislative Action Committee of Community Associations Institute. We oppose the measure. As indicated previously, basically a proxy is just a mechanism by which owners are entitled to designate someone to act on their behalf at the meeting. And it's a very democratic process. It allows owners to participate and designate someone that they wish to represent them at that meeting. That's all it is. And we have concerns that if the bill were passed, there would be some constitutional problems under the contracts clause of the US Constitution. If you have any questions, I'll be happy to answer them, but otherwise I stand on my testimony.
Thank you very much. Kim Koko Iwamoto in support. Do we still have her, Natasha?
No, not present on Zoom, Chair.
Phil Nerney in opposition. Thank you very much for standing on your testimony. Dale Head in support.
The microphones are on, but I don't seem to hear them like in the past years. I think I need
Maybe,
hearing
yeah,
aids.
maybe pull a little closer just in
I
case.
think I need hearing aids. I'm 75 now. Excuse me. But I had asked for this bill last year, 2 years before that. I've been coming down to the Capitol since 2016, trying to get fair play and voting rights for HOA members, all right? We were always opposed by the companies. When I did post-election audit of proxies, what I discovered, for instance, was there'd be 75 marked for the board as a whole, 26 for the board members to vote as they choose, but these were kept together as a single voting block, 101. We had 44, I had 44 proxies myself. We had 4 openings, 4 times 101, 404 votes. Who are they given to? The incumbents who had the least support from the owners. The people whose proxies were misused were not informed by the company how they used them. This is dishonest, but it's a business model, okay? This is the problem. We uncovered this, talked to the DCCA, they say, well, unless it was a licensed person, a realtor, can't do anything because that was a private affair. No, the company, yeah, it's a private company. It's not a public company, but they're licensed by the state of Hawaii. And they should be held to some standards of honesty, which they are not, okay? The only way to get honest elections is get rid of proxies. We're taxpayers. Give us a ballot. We've earned it. That's what we pay taxes for. Thank you. Bye.
Thank you very much. Sandy Wong in opposition. Oopsie, Sandy. Lourdes Scheibert in support.
Thank you for this hearing. In the present, I just wanted to highlight my written testimony. In the present management practice, where the board delegates daily responsibilities to a management company, a social disconnect has emerged between the board and the owner. The management approach acts as a barrier between the board and the owners, often leading to frustration on both ends. In the midst of this struggle, the board sometimes overlooks their primary responsibility, which include maintaining the building's infrastructure and safeguarding the interests of the owners and the tenants. The problem with the proxies to the board as a whole is the cumulative votes that gives an owner 4 sticks to vote for a can be voted to one person. If the board has control of, say, the majority of the proxies, they can keep voting themselves in for re-election. In the course of my investigation, I stumbled upon a testimony from 1984 delivered by Richard Ford, the former chair of the Hawaii Democratic Party, who supports a viewpoint strongly resonates with my personal conviction that it is of utmost importance to advocate for the removal of proxies in favor of alternative voting methods. In my opinion, implementing direct mail ballots to the owners would be an ideal choice for replacing proxies and ensuring a more effective and inclusive voting process. When we fast forward to 2024, the situation has worsened, resulting in an escalation of court cases and placing a significant burden on directors and officers of insurance claims. Please pass SB 2404 to the next level with the opportunity for more public review.
Thank you. Thank you very much. Greg Masakian in support.
Thank you again for an opportunity to speak. As I said earlier, I currently serve on my condominium association's board of directors. It's a fact that there is a serious abuse of power via proxy used to elect directors by board members who want to stay in power. It happens every year at my condominium association and many associations throughout Hawaii. Proxy is not a ballot, nor is it a vote by each owner of the association to elect their leadership. A proxy gives away what should be one vote for one person and how America votes for our elected officials. As legislators, you should be familiar with one person, one vote, which the US Supreme Court ruled on in 1964, the year before I was born, and Reynolds versus Sims, where the court held that the Equal Protection Clause of the 14th Amendment includes a one person, one vote principle. Americans get one vote, Americans get one ballot and one vote. So why do condominium associations in the state of Hawaii via HRS 514B-123 have a different voting process to elect leadership? There should be no need for any lengthy discussion on this bill. It is moving fairness and ethical elections in the right direction. I ask you to please support and pass SB 2404 and help over 1/3 of the population of Hawaii have fair elections within their condominium associations. Mahalo.
Thank you very much. Is there anyone else who would like to testify? Why don't you go first? You've been waiting, and she went 2 times already.
Okay.
You can go second. Good morning.
My name's Karen Lynn. I'm a condo owner. I wasn't planning to testify in person. I did send in support comments. I am desperately in favor of this bill. I agree that in principle, proxies have been around forever, and they're an important way for people who are not able to, say, attend an annual meeting to be able to be represented. But I take great, I know for a fact, because I spent the last week dealing with people in my condo, talking about the fact that there are probably 3 perhaps 4 people who will control all proxies for the annual meeting vote coming up next month. A lot of the owners are off-site, and so they put their trust in someone. However, if the board gets to vote as a whole, then they lose control. I'm totally in favor of a directed ballot, either a direct mail ballot or a directed proxy where you can write in who you want to vote for, but not kind of the board vote as a whole. So thank you for the opportunity.
Thank you.
Thanks, Chairman and the board, for your patience testifying again. I also am in support of this measure. I have seen the abuse of power with the proxies. Part of this is done by, there's not even newsletters on a monthly basis that introduce or talks about what's going on in the association. So if you get a proxy and the board as a whole votes for whom they want, it's not really fair. So each homeowner should get a ballot and put the name of who they want to. When that ballot is sent out, if someone is running, they need to have a bio on the person running. It needs to be fair that the AOAOs look for people that want to run and put their bios in and send it with the ballot. Oftentimes, the board won't even announce that you're up for re-election and you don't get your ballot, your bio in there. So I think it's abuse of power with the boards having the control of the proxies. Thank you.
Thank you very much. Is there anyone else who would like to testify?
Mr. Chair, I submitted testimony. I'd like to testify on that.
Okay, so I believe we have Kim Koko Iwamoto on screen, so we'll take you, and then the other individual, I did not catch your name on the top of the Zoom screen, but if you'd like to stand by, you can go right after. Okay, please proceed.
Thank you very much, Chair. On behalf of the Chamber of Sustainable Commerce and on behalf of the District 25 Council, we do support this bill to eliminate proxies in favor of direct or in-person voting. I'm not sure if other testifiers talked about this, but a lot of the community association contractors work in conjunction with the sitting board members. And because they manage a property, they need to maintain a database of all the condo owners' information, their personal cell phone numbers, their email addresses, and if their mailing address is different from the actual condo within the association, they have that address as well. They can, if they support a particular board member, they can garner proxies for that individual, leaving a challenger without the same access to contact information. And so when legislators tell condo owners, well, you guys need to pay attention to what's going on, it kind of ignores the disproportionate or the imbalance of power and access that the incumbent board members have through their relationship with the community association managers. So this would basically make it more even and get rid of that kind of imbalance of access. Thank you so much.
Thank you very much. And the next individual, please turn their screen on and identify themselves and proceed.
Yeah, Mr. Chair, I'm having some trouble with the screen here. But I submitted testimony on behalf of Hawaii State Association of Parliamentarians in opposition to Senate Bill 2404.
Can you identify yourself, please? Thank you.
My name is Steve Glanstein. I'm a professional registered parliamentarian, and I've done about 2,000 meetings, done about a half a dozen board removals last year. I had a board takeover last week, Saturday on Maui, where the board did not have a lot of proxies, and they were essentially replaced by another group. So I'm quite familiar with this process. I'm also an expert witness when it comes to proxies in the First Circuit. I did provide for the committee's consideration a history of what has been done with proxies, and this type of bill has been rejected in 2023, 22, 21, and even prior to that. When we put together Chapter 514B, we took comments from stakeholders and we worked out a balanced approach. We had a posting requirement, so that way owners who were put on notice that they could submit a one-page statement. Some boards go way beyond that and actually send out a save the date card because they're trying to get more nominees. We've had meetings like, for example, Moana Pacific, where it's a huge association, and I've been in the audience where my client has been successful at getting elected to the board. So it can be done, Mr. Chair. There's not a real issue when it comes to the proxy collection. It's a matter of having owners individually educated and knowing that they do have rights to get their name on a proxy form. With respect to the mail-in specific ballots, unfortunately, they're turning me into the election king of Hawaii for condos. It's not a position I want. But we are asking for some assistance over the next year because we do need to tweak the electronic voting statute, as we might be able to find something that is even more balanced and more efficient for condominiums to get their business done. So I am opposed to this bill as it is, and
Thank you very much.
Thank you, Mr. Chair.
Thank you. We are on SB 2404. Is there anyone else who would like to testify? Okay, members, any questions? Okay, we're going to move on to the next measure, which is SB 2493. But before we do so, I would just like to note to everyone who's been attending this hearing that we've been in the hearing for over an hour. It's a 90-minute hearing. We have approximately 25 minutes left. We've gone through 4 bills and we have 7 more to go. I'd like to make recommendations and vote on this measure before we adjourn this meeting. We purposefully scheduled all this stuff on the same day so that people wouldn't have to come back to the Capitol multiple times to get clarity on the decisions and recommendations that are made. So I would like to kindly encourage everyone to exercise some brevity in their comments going forward. Thank you. The next measure is SB 2493 relating to condominium association. This measure requires that the fees for attorneys retained by a condo association be paid from an association's funds or reserves, and limits the total and final legal fees to 25% of the original debt amount. First up is CAI, Mr. Nerney, in opposition.
Thank you, Chair, Vice Chair.
Good morning.
Committee members, I have submitted written testimony, and I simply want to highlight that the factual findings that are proposed are completely in error with respect to how condominium governance works, and that fundamentally, when there is owner misconduct, which is significant and substantial throughout the industry, that there are 2 choices. You can assign the cost of enforcement to the malefactor, or you can make all the other innocent consumers pay. That would be unjust. Thank you.
Thank you very much. Next, we have Dale Head in support. Thank you for standing on your supporting testimony. Sandy Wong in opposition. Good morning.
Morning. So I'll be very brief. Sandy Wong, here on behalf of Sandy Wong, I'm a condo owner and a condo resident. I am very opposed to this bill because I think it's unfair to the other condo owners who have nothing to do with it. It's perfectly innocent. So why should we pay for attorney's fees that was brought on by another owner? It's just not fair. So I ask the committee to hold this bill. Thank you.
Thank you very much. Jeff Cedino in support.
Good morning.
Good morning.
This will be my last testimony. My name is Jeff Cedino, and I strongly support this bill. This is a brochure that I received from the City Council a couple of months ago. On here, it says that $354 million of my taxpayer dollars went to the police department. Last year, even though I followed all of the laws, I still had to pay taxes to pay for the police, and this is accepted by all of us as being completely normal. As a member in a society with rules, I understand that a portion of my taxpayer dollars are going to go towards the police to enforce our rules. Imagine a world where the more violations the police find, the more money the police make. Every violation, no matter how small, gets thoroughly prosecuted. The more expensive the prosecution, the more money for the police. This Orwellian society is what the trade industry has created in our condominium governance. By changing attorney fee reimbursement to 25%, it will force the board members to ask themselves if the violation really is serious enough that it necessitates attorneys. Currently, with 100% reimbursement, the board members have no reason to ask themselves this question. You end up with situations where a $300 fine for something as inconsequential as having a messy porch gets referred to the attorneys, and over $3,000 in attorney fees get charged. 100% attorney reimbursement is the original sin of most problems that exist in the trade industry. Get rid of this just one thing, and you will witness a dramatic increase in dialogue between board members and owners trying to resolve their disputes without attorneys. Thank you for the opportunity to provide testimony.
Thank you very much. Marcia Kimura in support. Good morning.
Good morning, Chair Keoho Kalole and Vice Chair Fukunaga and committee members. Thank you for extending this hearing. I, of course, am in support of this. But I would stand on my testimony, but I have some other very important things to stress. If owners are complaining that they're footing the bill for legal charges against another individual owner, then the board needs to be more discretionary about its spending. Currently, they just, they go through the roof because they know that they're going to force an owner to be reimbursed. And when they hire attorneys on behalf of the association, they are the clients and they are obligated to pay the fees. But when they demand that owners assume the payments for other than delinquent maintenance fee collection, they wrongfully and non-judicially convict owners of offenses that were nothing more than speaking out against boards, which is a constitutional right. And the original framers of the in the absurd event that boards try to sue owners for legal fees from board retaliation, the owner who prevails may not necessarily recover his or her expenses as defendants of these suits. And condo attorneys as collectors of delinquent maintenance fees are legally bound by the terms of the Federal Debt Collection Practices Act. And yet their public denial of this has led to unwieldy, devastating fees on defaulting owners and others that they collect from. It's too late for many owners who lost their homes because of these injustices. But I do hope that
Thank you very much.
Thank you.
Thank you very much. Next, we have Christine Morrison in support. Lourdes Scheibert in support. Good morning.
Good morning. Thank you for this hearing. So my concerns raised in a recent article by Superbeat titled, "It Started with a Messy Front Porch, Now the Elderly Women Condo Association May Take Her Home Away," has garnered 139 comments. This article serves as an illustration of the worsening situation. It is so disheartening to see that under 514B, non-judicial foreclosure is being pursued against this elderly woman for alleged fines amounting to $300, along with the attorney's fees totaling $3,300. It raises questions about the impact on her equity in the condo if the association were to buy or sell her unit for $3,600. But I want to bring the committee back to the other statement that I made previously, is where the board delegates daily responsibilities to the management company. And this has created a social disconnect that has emerged between the board and the owners. The board directors need to be educated. They need to have a dialogue with their owners. And in that kind of dialogue and connection, social connection with them, then they can be able to ask for their own proxies in their own name, not have a property management company with the first block of giving your proxies to the board as a whole, and then the resident manager runs around and goes, oh, we need quorum, and the first block they're gonna check is a block for proxies to the board as a whole. Please support us. Thank you.
Thank you very much, Greg Masakian, in support.
I stand on my testimony, and I do want to say that I support the comments of the members of the public who just spoke in support of this bill, and I hope that you do also support it and pass it. Thank you.
Thank you very much. That's all the registered testimony. Is there anyone else who would like to testify? Mr. Head.
My name is Dale Head. But real fast about proxies. They are the holy grail for the property manager on how to hijack and steal the election. When the proxies are given to a company, only the property manager has them, control of them. Does not reveal to the board members how many were assigned to the board as a whole or to be voted by individual members. But yet, without a proper motion being made and recorded in the official minutes or on the election certificate, gives to who he wants. Usually incumbents who have low order support, that keeps them in power.
Mr. Head, if you'll permit me, we are on the measure about legal fees. The proxies we've heard and moved on yet. If you have comments about legal fees.
Sorry.
It's okay. That's okay. Is there anyone else who would like to testify?
Yes, Chair Keho Kolole, it's Kim Koko Iwamoto with the Chamber of Sustainable Commerce. I failed to submit the testimony, but I'd just like to make sure we go on record supporting this bill. Thank you so much.
Thank you very much. Is there anyone else?
I just want to support.
Okay, I would just like to note that we have 13 minutes left and I'd like to vote on these measures.
Okay, I just would like to strongly support this bill. Thank you, Nancy Manali Leonardo.
Thank you very much. Members, any questions for any of the testifiers? Okay, seeing none, we're going to move to the next measure on the agenda, SB 2727. This measure allows high-rise residential condominium properties to be eligible for commercial property assessed financing, or CPACER. First up, Hawaii Green Infrastructure Authority. Ms. Yamamoto Lau in support.
Good morning, Chair, Vice Chair, and members of the committees. Gwen Yamamoto Lau, Hawaii Green Infrastructure Authority. I stand on my written testimony in support, but I did want to highlight that this is a commercial financing program, not a consumer one. Our lender consent is already required in the statute, and we will not be placing any special assessments on the real property taxes of the individual unit holders. Therefore, it will not interfere with any secondary market sales. Thank you.
Thank you very much. Hawaii State Energy Office in support. Office of Planning and Sustainable Development in support. Hawaii Bankers Association offering comments. Petros Pace Finance, Michael Yaki in support.
Thank you very much. Good morning. My name is Michael Yaki, Senior Vice President of Petros Pace Finance. In support of this legislation, we stand under testimony and are available to answer any questions.
Thank you very much. Philip Nerney in support. Thank you for standing on your testimony. And Dale Head in support. Thank you for standing on your testimony. Is there anyone else who would like to testify? Members, questions? Okay, we'll move to the next measure, SB 2600. This measure authorizes the use of email to deliver certain documents when purchasing a condominium. Hawaii Realtors in support.
Standing on support.
Thank you very much for standing on your testimony. That's all the registered live testimony we've received on this. Is there anyone else who would like to testify? Six pieces of written testimony in total, all in support. Forgot to mention that. Members' questions? All right, seeing none, we'll move to SB 2532. Relating to crime, this clarifies that secured areas appurtenant to a multi-unit dwelling are included as dwellings for the purposes of prosecuting offenses under Chapter 708. Let me see. First up, we have the Attorney General's office with comments. Good morning.
Good morning, Chair, Vice Chair, members of the committee, Deputy Attorney General Trisha Nakamatsu, appearing on behalf of the Department of the Attorney General. We did not take a position on the intent to clarify burglary in the first degree, but we did provide some suggestions and proposed language that may help to clarify things for purposes of enforcement. I'll be available for questions.
Thank you very much. James Nelson, in support? Good morning.
Morning. Good morning, Chair and Vice Chair. Thank you for hearing this billing. I just wanted to clarify that I'm here in my personal capacity and I submitted testimony on my own based on my own experiences, so I didn't want there to be any perception of conflict in that respect. And I'll just point out that based on my own experience, it is possible to charge burglary under these circumstances, but I had to kind of do the job convincing the police and the prosecutors to follow up in that manner. So if the investigation is only for bicycle theft, then that's the way it will kind of always go. So I was just hoping that the statute could be clarified in that respect, and I'd be happy to answer any questions. Thank you.
Thank you very much. Dale Head, in support? Thank you for standing on your support. Lila Moore, in support? Okay.
Not present on Zoom.
Thank you. We have 5 individuals who submitted written testimony in support, and then the Attorney General's office with comments. Is there anyone else who would like to testify?
Please submitted written testimony in support.
So I'm going to ask that we please check with the clerk to make sure it's registered because I don't have it on my list. But thank you for attending on behalf of the Honolulu Police Department and standing on your support for the bill. Is there anyone else who would like to testify? Members, any questions? All right. Next measure is SB 2534 relating to condominiums. This measure prohibits condo unit owners or any person acting on behalf of the unit owner from harassing or interfering with board members, managing agents, resident managers, association employees, vendors, and a number of other individuals in the performance of their duties. Philip Nerney for CAI with comments. Thank you for standing on your comments. Dale Head in opposition. Thank you for standing on your testimony in opposition. And Greg Masakian in opposition.
Yes. Oh, sorry about that. I just needed to have the screen, the little pop-up so I could put my video on. Very brief statement. Pulling it up.
Go ahead.
Apologize. So I do serve as a director at my condominium association, the Keone AO, and I do not support this bill. As I stated in my written testimony, this bill looks like it was drafted by a condominium association board president as a means to further retaliate against owners and others who raise concerns about board actions or misconduct. It is misguided and unfair as it does not protect all residents of the association from harassment. Oppose SB 2534 and hope that the committee members see clearly what this bill is really intended to do. Mahalo.
Thank you very much. Is there anyone else who would like to testify? We'll go to you first, and then Sandy. And we have 5 minutes left on this hearing.
Nancy Manali Leonardo, I'm strongly opposed to this bill. I'm the victim of an assault in my garage. The board did not even write up an incident report. When I said check the cameras in that section that it happened wasn't working. I have been harassed on multiple occasions for pointing out leaking pipes or other things that are happening in my building. And so this bill is, I'm the daughter of a fisherman. And let me tell you what, you can coat this piece of filet any way you like, but it smells. It's wrong. It's basically going to allow the owner of the unit not to have a voice because it's sugar coated here very nicely. Sounds good, but it stinks.
Thank you. Ms. Wong?
Sandy Wong, I'm in support.
Thank you for standing on your testimony and support.
Did you want me to send something in writing?
Please do, yeah. Is there anyone else who would like to testify?
I believe I submitted written testimony, but I stand in opposition.
I'm sorry, what was your name again?
Lynn, last name is Lynn, and it was this morning, so it may have been too late.
Okay, I just asked if you can check with our clerk right here to make sure we have you for the record. Thank you. Is there anyone else? Members, any questions?
I would like to comment.
Okay, I would ask that you please comment as briefly as possible, or we will not be able to vote on these measures today.
Okay, yes, I just want to say that the bill, I'm opposed to it. It's too broad. You know, what exactly do they mean by harassment and interference? Is it physical threats? Is it just simply asking a question or reporting a problem with the association operations? It's too broad. Okay, thank you.
Thank you. Is there anyone else? Members' questions? All right, next measure is SB 2548. This measure requires employees and contracted vendors of condo associations that grant access to security cameras to undergo a background check. Let me see. CAI, Mr. Dallas Walker in opposition. Good morning.
Good morning, Dallas Walker for CAI. I stand on my testimony, available for questions. Thank you.
Thank you very much. We also have Dale Head in support. Thank you for standing on your testimony in support. Is there anyone else who would like to testify?
I support.
Thank you, Sandy Wong, for standing on your remarks in support. Is there anyone else? Okay, members, questions? All right, last measure is SB 2726. And this is the Legislative Reference Bureau report measure. So let me see. We have Richard Emery in support.
I stand on my testimony in support.
Thank you very much. Philip Nerney in support.
Briefly, Chair.
Sure.
Vice Chair and committee members. The legislature appointed a task force to study these questions. The unanimous recommendation of the task force was to proceed as is outlined in this bill, and I hope you will pass it.
Thank you very much. Jeff Sedino in support.
I will stand on this support.
Thank you for standing on your testimony. Dale Head in support. Thank you for standing. Greg Masakian with comments.
Yes, just a brief statement. And again, I'm just pulling it up. While I support SB 2726 and its intention, the urgency, severity, and frequency of issues impacting condominium owners throughout Hawaii warrants a more urgent and substantive response from our legislators and actions that will take effect in 2024. There's no more time to sit around waiting for reports that will only tell us what we already know, and previous reports have told us. The issues and concerns have gotten worse, more prevalent. Gregory Tanaka's 1991 report, Condominium Dispute Resolution, Philosophical Considerations and Structural Alternatives, should have been what was implemented in 1991. Let's not wait any longer. Thank you.
Thank you very much. Is there anyone else who would like to testify? Thank you for standing on your support.
Karen Lynn, I would like to support with the comment that I agree with Greg Masakian that there are a couple of issues here with time and possibly.
You're going to need to come up, and then we're going to have to defer this agenda. I'm sorry. Yeah. So supporting with comments. If we have your testimony written, then we'll make sure we note it for the record. If there are any objections, I'm going to move into decision making on this. Okay, we're in decision making.
For which one? The last one or something?
We're going to move on the whole agenda. I'm going to make recommendations. If everybody would like to get ready, and let's just check with our staff to make sure we're okay. Okay, so here are the recommendations. So for the first measure, SB 3205, after considering the testimony, my recommendation is to defer this measure in favor of the last measure on the agenda. What was proposed in this measure was not an ombudsman. And so we either need to have a discussion about appointing a condo czar, or we need to have a more thorough discussion about what an ombudsman is and how that might be a proposal worthy of consideration. The next measure is SB 2108. This is relating to the renewable energy tax credits. The recommendation on this measure is to pass with amendments. We will accept the tax foundation proposed amendments articulated in their testimony. We will accept the Department of Taxation's offer of defining the term related so that we can make sure that there's clarity. And we will adopt the Department of Taxation's proposed amendments, deleting the definition of transferee taxpayer in Section 4, deleting the phrase for fair and reasonable consideration on page 1, and postponing the applicability of the measure to January 1, 2025. We'll also defect the effective date on this measure, since it is a measure that needs further discussion, to July 1, 2040. Members, any discussion? Okay, seeing none, Vice Chair, SB 2108 passing with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
Yes.
Senator Richards?
Aye.
Senator Awa is excused. Measure is adopted.
Thank you very much. Next measure is SB 2336. This is the threefold damages for renters who prevail in a residential landlord-tenant code lawsuit. The recommendation on this measure is to pass with amendments. We will strike Section 3, and we will make associated changes to the preamble and defect the effective date to July 1, 2040. Members, any discussion? Okay, seeing none, Vice Chair passing with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Of the other members present, are there any voting with reservations or objections? Hearing none, measure is adopted.
Thank you very much. The next measure is SB 2404. This is the proxy voting bill. I'm going to recommend that we defer decision-making on this measure to Friday, February 9th at 9:45 a.m. while we conduct further research. Next measure, SB 2493. This is related to fees for attorneys retained by condominium associations. The recommendation on this measure is to remove sections A and C of the bill. So we'll take out everything except for the 25% cap, and we will defect the effective date to July 1, 2040. Any discussion? Okay, seeing none, passing with amendments. Chair votes aye.
Thank you. Vice Chair votes aye. Of the members present, are there any voting with reservations or objections? Hearing none, measure is adopted.
Okay, thank you very much. Next measure is SB 2727. This allows the CPACER funding. The recommendation on this measure is to pass with amendments. We will adopt the language proposed by the Hawaii Green Infrastructure Authority. And we will note that the requested language submitted by the Bankers Association, even though it's been attested to that, it's not going to be an issue. There are also some technical non-substantive amendments. Any discussion? We'll also defect the effective date to July 1, 2040. If there's no discussion, passing with amendments, Chair votes aye.
Thank you. Vice Chair also votes aye. Of the members present, any voting with reservations or objections? Hearing none, measure is adopted.
Just a quick note, we are deferring action on SB 2404 to Friday, February 9th, 9:45 a.m. in room 229. Next measure is SB 2600. This is email for condo docs. The recommendation is to pass as is. Everybody likes this one. Any discussion? Seeing none, passing on amended. Chair votes aye.
Take the win.
Vice Chair also votes aye. Of the members present, any voting with reservations or objections? Hearing no objections, measures adopted.
Thank you very much. Next measure is SB 2532. This is the clarification of multi-unit dwelling secured areas. The recommendation is to pass this measure with the proposed amendments submitted by the Attorney General's office and the effective date to July 1, 2040. Any discussion? Oh, you know what? Okay, upon the recommendation of Senator McKelvey, we'll keep the date clean, effective upon approval. So passing with amendments, any discussion? Seeing none, chair votes aye.
Thank you. Vice Chair also votes aye. Of the members present, any voting with reservations or objections? Hearing none, measures adopted.
Thank you very much. The next measure, SB 2534. This is condominium harassment. Reviewed the testimony. Recommendation on this measure is to defer indefinitely. Next measure is SB 2548. Let me see. Oh, this is the background checks for security cameras measure. The recommendation here is to pass with a defective effective date of July 1, 2040. Any discussion? Seeing none, Vice Chair passing with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Of the members present, any voting with reservations or objections? Hearing none, measures adopted.
Thank you very much. And for the last measure on the agenda, the recommendation is to pass this measure with amendments. There were some clarification amendments submitted by LRB, so we're going to adopt those. There already is a appropriation in the measure, and there are some technical non-substantive amendments. So just passing with the LRB amendment. Any discussion? Seeing none, chair votes aye.
Thank you. Vice Chair also votes aye. Of the members present, any voting with reservations or objections? Hearing none, measures adopted.
Thank you very much. And just a reminder, we have a joint hearing at 3 p.m. We are adjourned.